Okay, gentlemen, ALDRAP is Association of Legislative Drafters and Advocacy Practitioners. It is a non-governmental organization with a thematic area in legislative drafting. So ALDRAP is into capacity building and consultancy services in area of legislative drafting. ALDRAP trains lawyers, private practitioners who are interested in acquiring skills in legislative drafting. ALDRAP has trained and still trains members of the National Assembly of the Federal Republic of Nigeria, that's staffers, and in this area. ALDRAP consults for the Federal Ministry of Justice, Nigeria, for state ministries of justices, Nigeria, then private organizations that require such services, multinationals and international NGOs. ALDRAP has consulted for the Ministry of Justice of the Gambia, the Ministry of Justice of Rwanda, the United Nations, and currently ALDRAP is at the camp. So this training holds every work day, Monday to Friday, by 12 noon West African time, that is 12 p.m. Nigerian time, which is 1 p.m. Lesotho time. So that is it. The training is absolutely free. It runs for 3 months. At the end of the training, if you are interested in having a certification in this regard, you go through the qualifying examination or PIS assessment test, then after which you, of course, upon successful completion, you are issued a certificate after you have paid the processing, saddled with the responsibility of ensuring that this class holds non-stop, except on rare occasions, and that will be duly communicated to everyone. The gentleman sipping a drink on video here, his name is Professor Tony Clinton Jaja. He is the Executive Secretary of ALDRAP.
Okay, so we are doing this 12-week training course in legislative drafting. The real cost of this course is 21,000 euros. However, we are offering the course free of charge to members of the Law Society of Lesotho and some Nigerian lawyers. The reason is we are motivated to encourage people to study or specialize in the area of legislative drafting. Before now, the only way you could learn legislative drafting is if you belong to the Office of Parliamentary Counsel. You learn on the job. However, that approach has changed. We now believe that we need to combine on-the-job training and formal training in legislative drafting. So when we combine the two, you become a better legislative drafting lawyer. So that's why we are doing this training free of charge, so that people would get both a combination of formal training. This is a formal training. Then on-the-job training. On-the-job means the more you draft, the more you have access to drafting jobs, the better you become. So over to you, Ebenezer.
Okay, so thank you, Prof, for standing in. Like I said earlier, this is the first week of the training. We have had 3 days. Today is day 4, and we are still dealing with the introduction. So we have gone through the history of legislative drafting from 1869 till date. We have looked at the distinction between legislative drafting and other areas of law or legal drafting. we have looked at career opportunities in legislative drafting. So, we will just for the benefit, this is still week 1, what we have this week is introduction. So for the benefit of those who are joining us, we will have a recap of that topic and we will give assignments for today and tomorrow. Thursdays and Fridays are usually for assignments and class exercises. So I would suggest, if you have not done that already, that you get a notebook or your notepad or your electronic writing device, but have where you record what we are doing here, because you will always have need to refer to them. Thank you very much. Okay, history of legislative drafting. Those of you who have not introduced themselves, you are welcome. You will have time to do that, but we want to quickly dive into today's lecture. The history of legislative drafting as an area of practice dates back to the year 1869, when the British Council established, when the British Parliament established the office of Legislative Council, Parliamentary Council. Now, Legislative Council is US, so let's get that correctly. I said the history dates back to 1869, when the United Kingdom Parliament established the office of the Parliamentary Council. I am aware that Lesotho also have an office of the Parliamentary Council, so you can see where that came from. Prior to 1869, the Parliament of UK was made up of peasants, everyday human beings, business people, traders, artisans, maybe fishermen, maybe carpenters, maybe farmers, who were there elected to represent their various constituencies. And because these men were laymen, they were not lawyers. They were not skilled in the act of drafting laws. So they engaged the services of lawyers to draft bills for them. Now, these lawyers devised a very crafty means of making money from their clients by charging them per word. So it meant that if a lawyer wrote a bill, drafted a bill, and the bill was made up of, let's say, 500 words, the lawyer would charge £500, assuming they were paying £1 per word. If the bill was made up of 2,000 words, the lawyer would be paid £2,000. So because of this, lawyers began to draft voluminous documents as bills. And how did they achieve this? They used multiple words that simply meant the same thing. We call them couplets, use of multiple words that have the same meaning. For example, if they drafted a bill that says, anyone who willingly, willfully, deliberately, conscientiously, purposefully, intentionally drove at a speed of more than 120 per hour commits an offense, and upon conviction shall be liable to pay a fine of £10. The person is saying any person who willingly, intentionally, deliberately, consciously, conscientiously, are they not the same word? He would have said anybody who intentionally drives above above 120 kilometers per hour commits an offense. He could have just used one word, intentionally. But he chose to use 6 so that he will earn extra £5. And that was what they kept doing in everything they wrote. They will use 3, 4, 5 words that meant the same thing to make the document voluminous, because the more words they used, the more money they earned. That was one challenge. Challenge number two to these parliamentarians was that these lawyers also made that document difficult to understand by use of legalese. So they used legal jargons, which were some of which were Latin maxims, then some of which were not plain English but legalese, the language of the law, as we know it within the legal circle, which somebody who is not a lawyer will not easily understand. So this became another challenge to the parliamentarians, because when you pay lawyer A to draft, he will tell you, my contract with you is to draft your bill. I have drafted, here is your bill. So you will now have to engage lawyer B to interpret the bill that lawyer A drafted. So it became a challenge, making the parliamentarians to spend more money and also spend both ways. They will spend for drafting, they will spend for interpretation. Then came the year 1869, very important. The British Parliament met and agreed that they will no longer have lawyers draft bills that they cannot understand for them. That there was need to establish an office of parliamentary counsel. That office will be responsible for drafting bills for the parliament, and those bills will be drafted in such a way that the parliament will understand them. And these lawyers will be placed on monthly salary to work strictly for the parliament. So the office of the parliamentary counsel was established in 1869 by the Parliament of United Kingdom, the British Parliament. That is how legislative drafting as a distinct area of law practice came into existence. Now, the first parliamentary council to occupy that office is a man called Henry Tring. He was the first parliamentary counsel of the UK Parliament. Now, Henry Tring also wrote the first book on legislative drafting, which was published in 1902. The soft copy of the book is on our platform, but with the new platform, the joint platform that was created, we will share those materials on this other platform so that you can all have access to them. So, apart from the office of the Parliamentary Council, the British Parliament also established another office called Office of the Parliamentary Agents. Now note the distinction. There is Office of the Parliamentary Council, there is Office of the Parliamentary Agent. Parliamentary Council drafts government bills. Government bills are the equivalent of executive bills. Government bills are bills emanating from the executive arm of the government. So the Parliamentary Council drafts that bill. Parliamentary agents draft private member bills. They draft bills for individual members of the UK Parliament. What this means is that any bill that is not drafted by either the parliamentary agent or parliamentary council cannot make its way to the floor of the United Kingdom Parliament. Now, in United States of America, they also have their own equivalent. Because of standardization, don't also forget that America was colonized by the Great Britain. America established the Office of Legislative Council. Note the difference. America Legislative Council, United Kingdom Parliamentary Council. Note the difference. Now, what it means is that even in the US, it is this set of lawyers that draft for their Congress. Unfortunately, for us in Nigeria, any lawyer can draft a bill. But the challenge here is, how well will that lawyer draft the bill if he's not trained in the act of legislative drafting? So in Nigeria, our legislators engage any lawyer of their choice. If your younger brother is a lawyer, if your elder brother is a lawyer, if your relative is a lawyer, you can say, okay, by way of empowerment, have this brief and draft for me, draft this bill. But the truth is that the person will simply go online and copy and paste. Just copy and paste. The person will not even know the rules governing legislative sentences. You will get to know that. The person will not know the stages of drafting. You will get to know that. The person will not even know the four stages of a bill, the structure of a bill. The person will just model everything up. When, as a trained professional, when you pick the bill and look at it, you will just know that whoever drafted this has not undergone any form of training in legislative drafting. And that is what will distinguish you from every other lawyer when you draft and the person drafts. So that is the history of legislative drafting. Nigeria was colonized by the United Kingdom, and we inherited parliamentary council system upon our independence because we were running parliamentary system too. But when we migrated to presidential system, the office of parliamentary council, which was at the Federal Ministry of Justice, was scrapped, and we now have department, not longer office of parliamentary council, but Department of Legal Drafting at the Federal Ministry of Justice. Then you now have a subunit that is into legislative drafting. So that is the history of legislative drafting so far. Any question on the history before we look at the other two? Any question on the history of legislative drafting? Any question, please? Okay, I assume that your silence means you understood everything I said. Okay. So, what's the difference between legislative drafting and other areas of legal drafting? What's the difference? Legislative drafting, we agreed, is the process of reducing the intentions of Parliament to writing, concretizing it. You know, intention is immaterial. You cannot feel it. Intention is not tangible. You cannot hold it. You cannot even see it. So the intention of the Parliament dwells in the mind of the Parliament. So it exists in the realm of wishes and thoughts. You can't feel it. But what you now do as a legislative drafter is to bring that intention of the Parliament into a concrete form by way of drafting. So any law the Parliament conceptualizes or initiates in their mind, you make it a reality by drafting it. So legislative drafting is the process of bringing the intentions of the Parliament into documented form. That is one. It is also the process of producing legal documents used in parliamentary or, yes, in legislative business. When we say legislative business, activities that happen within the legislative houses, either as a parliament, in our case, the National Assembly, or in the case of the United States, the Congress. So, that is simply what legislative, that's the simplest definition of legislative drafting. Now, what distinguishes it from other forms of drafting? We said it is the process of producing documents, not documents, documents used in legislative business. So what are these documents? You have a bill, which is a proposal in form of law, a proposal, a law you are proposing that it should be formed and made enforceable. by way of presidential assent. So a bill is a legislative proposal. Two, you have motions. Motions are applications, prayers you want the House to do or honor. So if you have any application you want the House to approve, you bring it by way of motion. Then you have order paper, which is like a table of contents or agenda of the House for the day. These are the things that will happen. Today's legislative business. We have a motion from Senator A. We have another motion from Senator B. Senator C. We have to argue his bill. You put all those, that's order paper, the business of the day. Then, number four, you have compendium of financial estimates, which is 1 year annual budget that accompanies any bill that seeks to establish a government agency. So if you are bringing a bill to establish a government agency, you prepare a 1 year budget in advance, comprising of every cost that it will take to establish that agency for 1 year. That includes the number of personnel and their salary, the operational vehicles, the head office, to the tiniest pin, to stapler and the staple pin. All those things, you capture it in a budget format. You also have a bill analysis report or bill scrutiny reports. When a bill is presented to the House, before arguing the bill, the honorable members sponsoring that bill will circulate that bill among the members of the Parliament. And each member is to go through the bill and come back on the agreed date with a view to supporting the bill or opposing the bill. But before that date, he has to read through the bill. Most times they are not the ones who read. He may read through and give his legislative assistants to do an analysis of the bill. Tell me whether this bill should fly or not. Now, that is where you come in as a legislative drafter, because a person who is not a professional will not be able to do thorough analysis. When you are doing a bill analysis, your knowledge of constitutional law comes to the fore. Your knowledge of human rights law comes to the fore. Your knowledge of administrative law comes to the fore. Now, these are tools you deploy or skill sets you deploy to do a quality analysis of any bill. But the person who is not trained, even though he's a lawyer, he will analyze a bill and you will have conflict between the Constitution and that bill. You will have conflict between decided cases by the apex court of the land and that bill, because he is not trained. So these are a few of the documents. Then what are career opportunities available to you as a legislative drafter? One is that you can become a consultant, just like Prof. You can also become a lecturer like Prof. Two, you can become a legislative assistant to a legislator. So you do these things I mentioned, because if you are engaged as a legislative assistant, what I just mentioned are just a few of the scope of your job as a legislative assistant. You will also provide advisory services. Prof here at some point consulted for the Supreme Court of Nigeria. There was a case that involved legislators, not as individuals, but legislators as a body. And he was called upon to do a legal opinion, because that is his field of expertise. and he did that. It was not done free of charge. You'll be paid as a consultant. So you can work in the law reform commission of your country. We have a law reform commission in Nigeria, and I believe there is an equivalent in Lesotho. So you can work at the law reform commission. And we also have topics here on law reform and law review, where we get to know what the differences are. Okay. Okay, there's a question here. I will get to the question. Thank you. Question says, why do we speak of legislative intention when considering policy initiation and policy making? The actual intention is that of the executive to address socio-economic, political, and legal problems facing the nation. In this context, Parliament seems to be enacting or having the policy expressed in legal language. So, both conceptually and in real terms, the intention seems to be that of the executive. Thank you very much for this, Makwa Kachane. I hope I got the name correctly. I thank you for this. Thank you for bringing this up. Now, we need to know that there are different types of bills. We need to know that there is an executive bill. There is a parliamentary or legislative bills, that's private member bills. Then, in rare cases, we have bills emanating from the judiciary. Now, these are different forms of bill. When we talk about the executive, the intention of the executive, that is in respect of bills that emanated from the executive. Yes, at the ministry level, policies are initiated, but when these policies when they want these policies to become law and enforceable, they push it to the Ministry of Justice to draft bills out of this policy. That one is called executive bill. 1. 2. There are bills that come from private members of the parliament.
Ebenezer, your time may soon go off. They may log you out.
So there are bills that emanate from private members of the parliament. We call it private member bills. So it is not always the intention of the executive. You know why? When the executive brings a bill, what they are bringing is just a bill. The parliament, we will do a process of lawmaking. When a bill is brought to the parliament, what goes out is not, it doesn't go out the way the executive brought it in. The parliament makes their inputs. The parliament drafts the bill the way they want it. So at the end of the day, it is the intention of the parliament that is passed into law. Sometimes there is a conflict where the bill has been sent to the president for assent, and the president denies assent. The president can declare that he's not signing. One of such reasons might be that the bill has not reflected what they wanted. But there is a time frame where if president denies assent, the parliament will still pass the bill. So you see that every law you see is actually the intention of the parliament. What the executive brings are proposals in form of bills. But when the bill goes through first, second reading, goes through committee, goes through public hearing, it is no longer the same bill that was submitted by the executive. It has gone through changes. And what the parliament finally agrees to is what becomes the bill, is what becomes the law. So the executive, in the person of either the president or the governor, merely assents, agreeing by way of signing to what the parliament has brought out as the law. I hope that clarification answers that question. There are a few assignments here. Okay, so please look at the in-call messages. You will see there is an assignment there. Exercise an assignment. Redraft the section below in plain language. Please everybody look at the in-call message. There's a pinned message there. It's an assignment. You know, we talked about today being Thursday, we are going to be having assignments. The same will be applicable tomorrow. So, any question? Any other question? Any other question? Do you have any other question? Okay, let's make progress. Career prospects, that's where we were at. Career prospects in legislation. Okay, Prof, your hand is up, sir.
Okay, the man that asked the question, why do we say legislative, not executive? There's even a case law in Nigeria. Once you, as an individual legislator, you have copyright to a bill. You are the one that drafted this bill. The idea in the bill is yours. However, the minute you submit it to the parliament, you have lost the copyright to that bill. In fact, in our Nigeria, that case law says it is the Attorney General that has the copyright. He's the custodian of the copyright of all the laws of Nigeria. So I hope you get the point. Then you can read the case law of Pepper versus Hart. When the wordings of any law is ambiguous, where do you look for the real meaning? You do not go to the executive to find out what is this law about. You have to go to the Hansard. The Hansard is the verbatim report of the proceedings on the floor of the House. All the debates, the back and forth debates. It is in the Hansard you will find what was the intention of that law. So it's not the executive that tells you their intention. It is the legislature. Although the executive submits the bill, at the point where they are submitting the bill, they have copyright to the bill. But once they submit it to Parliament, the bill is no longer owned by, the copyright is no longer the executives. It belongs to the Parliament. And after the law is passed, the Attorney General is the custodian of the copyright of all the laws of the country. All right.
Thank you, Prof. Thank you very much. So you can also be an author. Our erudite professor has authored more than 10 books, apart from articles in different journals, both locally and internationally. So you can become an author, write books in different areas of legislative drafting. You can become a legislative advocate. Now, legislative advocacy, our name, ALDRAP, is Association of Legislative Drafters and Advocacy Practitioners. So legislative advocacy is more like mobilizing and lobbying for or against the passage of a bill. Shedding light, you can bring in a memorandum telling the legislature why this bill should be passed or why this bill should not be passed. And it's a good job, legislative advocacy. So you can be a legislative advocate, you can be a drafter, you can be a lecturer, you can be a consultant, you can be an author, you can consult. Once you are a consultant, of course, anybody can engage your service, whether the government or multinationals or an NGO. So the career prospect in legislative drafting is robust and unending. Okay, thank you. You said it is clear. So please look at the assignments on the in-call messages, look at the assignments there. We will have, okay, Prof, you have the floor, sir.
Okay, so in addition to all these career prospects, yesterday I told you there's something else, a new career prospect for legislative drafters. It's called editor, legal editors. Even in Lesotho here, the EU funded the position of legal editor for the Law Reform Commission. When laws are being reviewed, you need an editor. An editor is a lawyer who does not draft, because the person who drafts is different from the person who should edit. The reason is, when you draft, there are many things you may not think of. In fact, let me share with you the way the United Kingdom does drafting. They call it the 4I principle. 4I. On every bill, there are 4 lawyers, 4. So 2 of those lawyers are the drafters. The remaining 2 are called the checkers. That's how bills are drafted in the UK. Every bill has 4 lawyers working on them. 2 of them are drafters, 2 of them are checkers. The checkers will make sure that they use their manual to make sure that the drafters have complied with all the conventions in legislative drafting. So it's a new career path in legislative drafting. Australia has it. I spoke with the woman who is in charge of editing all the laws of Australia. She's called the legal editor. In Lesotho, you have the EU funded one of your King's Council. He was the legal editor for the laws of Lesotho. He edited to make sure that everything is good. So that's an area that is coming up. Then there's also language translator. I look at the Parliament of South Africa. They publish the laws in Sesotho, Zulu, and the major languages of South Africa. So they need a lawyer. I saw they were advertising for a lawyer in Sesotho who would translate the English laws into Sesotho. So it's an area of law that is, legislative drafting, where you can get employment. If you go to the Parliament of South Africa, it's a mandatory requirement that their laws should be in Sesotho, Zulu, and other languages, the official languages, apart from English. So you have lawyers who translate the law into Sesotho. In Canada, it's also an area of practice. They call it jurilinguists. They are lawyers who translate from English to another language.
French.
Because in the Nigerian constitution too, they say the business of the National Assembly can be conducted in English,
Igbo, Hausa, and Yoruba.
Igbo, Hausa, and Yoruba, 3 native languages. So if your constitution has that requirement that apart from English, the law should be put in the language of Sesotho, then you need a lawyer who knows Sesotho to translate from English to Sesotho. South Africa is already doing it. So that's an area of law that people are specializing in. Ebenezer has missed out. Today we wanted to talk about, the first topic in our course is, what is legislative drafting all about? That is just what is legislative drafting all about, then the history of legislative drafting. So today I posted the materials we were to use. There's a definition of legislative drafting which you must know, because that's the most important thing you should know as a drafter. What is legislative drafting all about? What is this whole thing about legislative drafting? The definition of legislative drafting is a law is a process where when you draft, you introduce mechanisms. Notice the choice words. It's the introduction of mechanisms for achievement of the objectives of the law. So if you draft any law and you have not introduced mechanisms for achievement of the objectives of that law, then you have wasted your time. So as a drafter, that's the number one goal of any drafter. There are other goals, but the number one goal for any drafter when you're drafting a law is, how do I introduce mechanisms? Notice the word mechanisms. It can be 1, 2, 3, 10. How do I introduce mechanisms for achievement of the objectives of the law? So every law has an objective. So you need to ask who is sending you to draft. You need to ask them, please, what is the objective of this law? Or the objectives. It could be many objectives. So for each objective, you introduce a mechanism.
We answered the question in your absence, but briefly, let me quickly do that while others join us. Your question was on the difference between legislative drafting, right, and the bill.
Yes, sir. Yes, sir.
Good. And we said that a bill is a document. A bill is a legislative proposal made by the National Assembly, and it could be from the executive, it could be from the judiciary, it could be by an individual legislator, a private member. It could even be, your second question was who is qualified to sponsor a bill, right? Who is qualified to bring up a bill and to draft. For drafting, it is the lawyers primarily, then better still who are trained in the area of legislative drafting. But any Nigerian can bring up a bill. You can, as you are, you can bring up a bill. But the challenge and limitation is that you cannot enter the floor of the House to argue your bill or present your bill. So, as an individual, when you bring up a bill, you look for a senator or a member of the House of Representatives who will sponsor your bill. So you can bring an idea up, you can see a problem in the society, put up a bill around it to solve it by way of legislation. Then you look for an honorable member that has already been elected into the House and give him the bill as the sponsor of the bill, because every bill must have a sponsor. Even executive bills are sponsored by the majority leader of the House. So what it means is that if a bill is emanating from the presidency or from the executive, yes, the president writes a cover letter attaching it to the bill, and that cover letter is given to the majority leader of the House. Of course, majority leader will always be a member of the ruling party. So he is the person who will now sponsor the executive bill. But if it is private member bill, any legislator will sponsor his own bill. So even the bill you wrote as a private citizen and brought to the member owns the bill because he has the platform you do not have. He can enter the assembly. He was elected for that purpose. You are not elected. So you cannot, as a private individual, come to the floor to make submissions on a bill. But the executive, the honorable member or your senator is already elected for that purpose. So to simply answer your question, a bill is a legislative proposal, a document, but a proposal that this document become law, because we will still do with the processes of lawmaking. You will now see how a bill moves from becoming a bill to becoming law after going through first, second, third reading, and the activities, what happens during first reading, what activity happens during second reading, what happens at the third reading. So these are the things we will look at. Then finally, before it becomes law, even after the president has signed, what should be done? So we will look at those things. But to answer your question, a bill is a legislative proposal, while the persons who are qualified to draft are primarily lawyers, but better who are trained in legislative drafting. Then those who can argue or move bill are elected legislators. Elected legislators. not private individuals. If whether it is a bill emanating from the executive, from the judiciary, or from private members, it is because one of the major what would I call it now, tasks of your legislators is lawmaking. One of their functions, cardinal functions, is lawmaking. They have lawmaking. They have oversight function too. Then they have representation fused in one. So while they are there, they are representing you. They are having oversight function on the executive and judiciary by the principle of not just separation of power, yes, by the principle of separation of power. Then they also have the lawmaking power. So that's why they are called lawmakers primarily. So they make laws, they represent you, and they exercise oversight function over the principle of checks and balances, not not separation of powers. Principle of check and balance is still under separation, but there should be checks and balances so that the executive does not overly use its power, the judiciary does not also overly or wrongly use their own power. So that is why you will hear that the House has invited so minister to come and report to them. Or you will hear that the House has gone on oversight function to so ministry. So I believe that answers your question. Hello, Mr.
Yes,
Emmanuel.
very, very, very much, sir. Thank you very much. But please, if I can just add a little question in consonance with what you are saying, sir. I would like to ask that, please, in which way, I mean, is it possible for a person as a citizen to be able to influence government policies in order for the government officials or the administrator or the president or the leadership of the country to embark on the kind of a policy of which we can change the system of adhering into the system, such as a punishment for the offender. My question basically want to refer to the extent of the which we in Nigeria, we only have law. For instance, I'm sorry to say this, but we have to be sincere in most cases that we just have law. Most of our laws are not properly administered, are not properly carried out. Now, my question in respect of this public legislative drafting is that how can I or you as an individual, is it possible? You have already explained how we can do it by influencing the representative into the House. But is it possible for us, for you or I, to make sure that the government embark on the adhering into the policy, such as which can give us a reasonable society, a reasonable country, a reasonable society to adhere with rules and regulations. For instance, in the light of the transport, transport or every other law. So I'm just trying to go so that we can be able to have a sanity in our society, sir.
That is already happening. Have you heard the word civil society group or civil society organization before? Hello, Mr. Emmanuel.
Sir?
Have you heard about civil society organization before?
Yeah, I mean in the sense that how we can influence the government to give us a standard adhering to the law.
Can you listen to the explanation I want to give you? What you are saying is already happening, and that is what civil society organizations do. That is what some NGOs do. For example, ALDRAP is not a government establishment. ALDRAP has noticed that there is lacuna in area of drafting quality bills. And ALDRAP traced the problem to lack of experts in drafting. And ALDRAP have decided to solve that problem by way of training lawyers to draft.
Okay.
Now,
Okay.
there is an NGO called Connected Development. Their nickname is Follow the Money. There is another NGO called Budget It. What Connected Development does is, after the government has read out budgets, as they are doing currently, then resources are all allotted to different agencies. We are going to build road here, we are going to build hospital here, we are going. Connected Development, we follow the money. That's why they nickname themselves Follow the Money. Then we follow the money to say, okay, this money, has it been moved? You have passed the budget, has funds been disbursed to so and so ministry? If the money has been disbursed to ministry, has the ministry disbursed to contractors? Now, that is the work of civil society organization holding the government accountable. So you as an individual, you can also do it. How can you do it? Write a newspaper article in that regard. We are talking about legislative advocacy here. Do you know that there is what we are doing, legislative drafting now? Then, what about after the law has been passed? Do you know that there is monitoring and evaluation? It is also an aspect of career in legislative drafting. That is post now. Scrutiny of what is being done by the law that has been passed. So as an individual, you can do it. If you pick up your pen now and write a beautiful article identifying where there are gaps, and you share it, and you do it consistently, and you tell the government, this is what we have noticed in this area, this is what you have noticed, and you are consistent and at it, you will be sure that by the time you do that 3-4 months, either a radio station phones you or a television station phones you to say, this thing you are talking about, come and say it on our platform. You go there and talk about it. When you finish talking, the government has seen, the government has heard you. You will think they do not hear. That is not true. I use myself as an example. In 2019, July 2019, I may not be able to remember the exact date, I was on Radio Nigeria. They invited me, and what was the topic? Setting agenda for the 9th Assembly. I will never forget. And they asked me questions along that line. What would be my suggestion? Because we just came, the 9th Assembly, they were just being sworn in. We just finished 2019 general election. And they were being sworn in. And they asked me, setting agenda for the 9th Assembly. And part of the recommendation I made there was that we have a lot of obsolete laws. We have a lot of colonial laws, that our legislators should look at those colonial laws and repeal them, amend some, so that they can capture current realities of the day. I specifically mentioned the Police Act. Then, I mentioned the Marriage Act. Then. So, imagine my joy when in 2020, a new Police Act came into force. Am I saying that it is the recommendation I made on radio that prompted it? The answer is yes. The answer is no. It was on network service of Radio Nigeria. So what it meant is that anybody that tuned in could get it from any part of Nigeria. Now, also note that your legislators have people who watch television and feedback and give them feedback on what the people think. So I did that in 2019. Now you can also do that. The result is okay, Prof, your hand is up, sir.
Let's get back. Let me finish this topic and you can continue.
It's okay, sir.
So we said the definition, what is legislative drafting all about? If you forget everything, don't forget that the reason you draft a law, there are two things you're looking for when you're drafting a law. If you're called upon to draft a law, the first thing you ask is, what are the objectives of that law? Once you identify the objectives, 1, 2, 3, 4, it can be 20, 100 objectives. So you ask the person who is instructing you, please, what is the objective of this law? What do you want to achieve with this law? Once they have told you, the next thing you need to do as a good drafter is you need to draw up what are the mechanisms you would use to achieve each of the objectives. That is what legislative drafting is all about in a summary. So that definition means effectiveness. Effect means that you are making a law that has effect. You know the law of nature, cause and effect. That when you draft any piece of document you call a legislation, it should have an effect. So effectiveness means that the law you have drafted has mechanisms for achieving the objectives of that law. That is when you know you have drafted a good quality law. Otherwise, what you have drafted, if it does not have mechanisms for achieving the objective, you have drafted literature, poetry. Go and join the literary society. That's where you write poetry. But in legislative drafting, when we write, we have a purpose, a target. The target is we introduce mechanisms to achieve the objectives of that law, or the objective. Each objective has a mechanism for achieving the objectives. That's how we write in legislative drafting. If you are not writing like that, please go and join the literary society. That's where they write prose, poetry, drama. Those ones, they don't have effectiveness as the #1 goal. The paramount goal of any legislative drafter is effectiveness. Effectiveness means that you would introduce mechanisms for achievement of the objectives. That's the definition of effectiveness. In fact, in serious jurisdictions where they are serious about laws, if you draft any law and you did not put these mechanisms for achievement of the objectives, there is a penalty for you as a drafter. Because any law you draft that is not effective, that is not well drafted, it results, one of the signs of a badly drafted law is litigation. Because litigation is required. Because if a law is well drafted, it's plain for the common man to even understand. But when you do not draft it well, then you need the courts to interpret, oh, what does it mean here? What does it mean here? Once there is litigation on a law, it is an evidence that that law is poorly drafted. During my PhD, my supervisor told me, you cannot just say Nigeria's petroleum law is badly drafted. Where is your evidence? Where is the litigation to show that Nigeria's petroleum laws are poorly drafted? I had to look for 500 litigation. 500. That's when I submitted. That's when they said, Dr. Jaja, you have done well. So the evidence of poorly drafted laws is litigation. When a litigation is required to tell you what does Section 5 mean, because it's not plain. In serious jurisdictions, in Canada, for example, there's a law called Legislative Negligence Act 2003. If you are a drafter, a lawyer, you work in the Parliament of Canada as a drafter. If you draft a law that results in litigation, your salary as a lawyer would be deducted to pay for a lawyer to go and defend that case in court. Because it was negligence as a drafter that resulted in that litigation. Those are jurisdictions that take drafting very seriously. And I told you in US they have a 2016 law. It's called Plain Language in Legislation Act 2016. So these are jurisdictions that take drafting very seriously. If you draft in a manner that you are not effective, then your salary will be used to pay for the litigation until it's exhausted. If the matter goes all the way to Supreme Court, they will start deducting your salary until the Supreme Court gives a judgment. So that's how serious, when you're drafting, how to introduce mechanisms for achievement of the objectives of the law. That is what legislative drafting is all about. Once you know this principle, you can draft any law. So the first question you ask anybody instructing you, what are your objectives? Then, once he has told you the objectives, if there are 100 objectives, you start with number 1. Objective number 1. What mechanism can I introduce as a drafter to solve this objective number 1? Number 2, what mechanisms can I introduce? And it's not something you have to think and come up with the mechanism that works. So I'll give you an example. In Nigeria, since 2003, we have anti-corruption agencies we established by law. The objective was to solve the problem of corruption by government officials, public officers. When they get into office, they want to steal the money. So we tried many mechanisms. We said maybe death penalty for corrupt people, maybe imprisonment, long term. All these mechanisms were not working. In the year 2016, we tried another mechanism. How do we reduce corruption? So one of the mechanisms we tried is called the whistleblowers policy. Whistleblowers. The Ministry of Finance of Nigeria said, okay, what will happen is, if you know that somebody has stolen money from the government, if you report to the person, we are going to pay you 5% of the recovered money. 5%. So the Ministry of Finance of Nigeria created a website, a portal on the website. If you have information about stolen government money, report on that portal. We will come, we will recover the money, we give you 5%. So that was an incentive. Instead of saying, oh, people should go to prison for corruption, do you know what happened? Within 3 months, that website crashed because there was so much reports about stolen money. So that was a mechanism for solving the problem of corruption, which the other laws have not addressed. The other laws were thinking that, oh, if you use imprisonment. But because we use this incentive, pay people money to report when they report about corruption, we had a positive result. So whenever you're drafting, as a drafter, effectiveness is your number 1 goal. There are other goals you can achieve: plain language, precision, and unambiguity, gender neutral. These are supporting goals for a drafter. But the number 1 goal is effectiveness. I want to be effective. I want this law to be effective. So the effect means it will achieve the objective. That's your number 1 goal as a drafter. All other goals are just secondary goals.
Please, Prof. Sir, can you cite the Indian example on effectiveness?
Okay, you have to carry on with that. I need to excuse myself.
Okay, sir.
All right.
Okay, just one example, another example on effectiveness, and we close the class. Some years ago, India was, how do I put it now? India was having the gold medal in World Open Defecation, meaning that India was the number 1 country in open defecation world over. And it became a challenge to the Indian government and parliament. And they wanted to solve that problem. They made laws and put in penalties for open defecation, and it did not work. They put in imprisonment for open defecation, it did not work. They used police order it did not work. Then they realized that they are a highly religious nation. India has over 3 million gods that they worship. So they looked among those their gods, the one that is highly revered by different religions, and they used the name of that their god. So they didn't need to do imprisonment again. What they did was to use ordinary notice. They will come here and write, do not urinate here. The temple of Vashti used to be here. They will go to another place. Do not defecate here. The temple of Vashti used to be here. And within few months, India dropped in open defecation because the people, they utilize the mechanism that the people can easily identify with. The people revere their gods. They revere the temple of their gods. So anything that will bring about desecration of that temple will be avoided. So it was the same people, the same place, the same problem, but different mechanism, because we are talking about effectiveness of mechanism. Now, in the case of Nigeria, he cited, the mechanism used there was incentive. Anybody who reports a corrupt person, anybody who reports stolen money, if you say, Mr. A, go and check this house, he has statues of stolen money there, the government will give you 5%. So that incentive of 5% became a motivation. Unfortunately, that policy failed because it remained at the policy level 1. 2, it was not concretized into a law. There was no legislation backing it, so it never became a law. Then, because it did not become a law, on the side of the government and Minister of Finance, there was no compulsion for them to live up to that promise. So people were not given their 5%. You see, issue of consistency. So that made the policy to fail. But in the case of India, they tapped into their religious obsession. They tapped into the reverence they have for their gods. As Prof said, the mechanism must not be one. But look at what do I inject into this law that will solve the problem. So understand it this way. Every bill that is brought to you to draft is a problem that is tendered before you. In drafting, you provide a solution to that problem. And the only way for you to provide a solution to that problem is to bring about mechanism that will make the law effective. There was a time in Nigeria, it is still ongoing, gas flaring. In the 70s, a law was passed against gas flaring. And they put a penalty that was so ridiculous. Now, Nigeria has a lot of oil deposits, and there are a lot of oil exploration going on in the Niger Delta of Nigeria. Now, instead of arresting the gas, instead of collecting the gas into liquefied natural gas, they leave the cost of distillation or processing the oil, they leave the gas to flare. You just see fire burning endlessly, but as that fire is burning, it is gas that is going. If you go to the city of Port Harcourt, there was a time, I think that challenge is still there, they have challenge of suits from fire burning of gas flaring, just resting on people like that. Now, this law came into place to stop oil companies from flaring gas. Rather, they should install equipment that will make them collect the gas. Now, the oil companies weigh between collecting the gas, what it will cost them to buy those equipment to collect the gas, and they find they will pay for gas flaring, they preferred to pay the fine. We now see that that law is not effective. So before the oil company will even start gas flaring, they will go and first of all pay fine in advance. We are about to flare so and so. This is the penalty. Then they will go and start doing the thing the law intends to stop them from doing. You will see that that is a classical example of a law that is not effective. The bill was badly drafted because there was no mechanism to solve the problem of that gas flaring. The law was just there to collect fine. Assuming they sell equipment for collection of gas, let's say 10,000 naira as an example, and you put the penalty for gas flaring at 50 or 100,000, you will see that the companies will comply. They will prepare to pay the 10,000 naira and get the gas collected than to flare the gas. So the law has no meaning. Like Prof said, it is just prose. It is just literary because it has no teeth to bite. It did not solve the problem of flaring. Is that understood? So, any questions as we begin to round up for today? Don't forget, check the in-call messages. There's an assignment that Prof gave earlier before we logged out. So kindly do the assignment and submit to him. Any questions on this, please? We have overstretched our time. Okay, in the absence of any question, I assume we all understood what we have said so far. Remember the mission of legislative drafting. Okay, Mr. Emmanuel, you want to say something?
Hello, I only want to say that it's well. I only want to say that it is well understood, sir.
Sorry?
I wanted to say that the lecture is well understood, sir.
Okay, thank you very much. Thank you very much. So on that note, we have come to the end of today's class. We see you guys tomorrow.